Is there a municipality, a state, anywhere in the country where you would say has the best self-defense laws that you would say that would be perfect to standardize nationally? Is there an ideal that you can identify that we could strive for that I could put in writing and provide to people? Because I've already had state senators reach out to me because they actually saw my post once it started to go a bit viral. And I'd love to be able to give them that as an example. Is there anything that you would say in this country is the model that we should aspire to nationally?
The truth is, self-defense law across the 50 states is largely the same. The fundamental principles are the same. Of course, they all have their own statutes and case law and jury instructions, but self-defense law is very old law, folks. I mean, it's as old as human civilization. It goes back to the ancient Greeks and Romans for sure. In America, it came from Old English common law. It doesn't vary very much in the American states. The biggest variance is there's 11 states that impose a legal duty to retreat before you can use deadly force to defend yourself. 39 states don't do that. That's really the biggest variance. So it's not the black letter of the law that differs so much. It is how it's applied that can differ a great deal between a California and an Oklahoma and a Texas and a Massachusetts. And that's all part of that prosecutorial decision-making. And when they're not held accountable for loosey-goosey decisions and just dragging people into court on a whim, that's when we see these cases happen. But the self-defense law of Massachusetts, for example, is not much different than the self-defense law of Texas. On the margins, it's a little different. I mean, you'll see differences other than stand your ground. You'll see differences in self-defense immunity laws, or you'll see differences. Defense of property varies a lot among the states. So when I say self-defense, I mean defense of persons, defense of yourself or defense of others. Very, very stable. Defense of property, defense of dwelling, defense of personal property. We see more variance there among the states, like whether, for example, Texas has this legal presumption of a reasonable fear of deadly force harm from an intruder who's forcibly, unlawfully entered your dwelling. We see that coming up in a lot of these Chad Reed discussions. Not every state has that. About half of the states have that kind of legal presumption. But there's not one state that has exceptionally good self-defense law compared to the others. The question is, how is it being applied? How is prosecutorial discretion being used? And unfortunately, if there's no check on that, when you have that discretion in the hands of an old school traditional prosecutor who does things in the old way, it's not been a problem. So everyone's been very comfortable with it. But when you put that discretion in the hands of someone who's explicitly politically motivated, well, then you get politically motivated prosecutorial decisions. And it's havoc, as they might have said in the
I'm thinking in terms of
Rittenhouse case.
Castle doctrine in the way it's literally meant, not the way it's incorrectly applied, as you mentioned in one of your videos, but and stand your ground. Like in Massachusetts, you clarified it a bit, but from everything I was told, as an avid gun owner in Massachusetts, if someone breaks into my house, I have a duty to retreat unless there's an immediate threat to my life, even within my house with my kids 5 feet behind me. So that's the sort of thing. If there was, although you can't standardize that nationally because it would be a 10th Amendment issue, but there has to be some way to do that. Just to give you an example on my.
So that's how things can get altered on the margins. So the principle of the Castle Doctrine, meaning if you would have had a legal duty to retreat out in the public street, you're relieved of that legal duty to retreat if you're in your home. Every state has that in that generalized sense. But some states then begin to constrain it on the margins. So, for example, Massachusetts will say, well, in most other states, we'll count, for Castle Doctrine purposes, we'll count not just inside the 4 walls of your home, but also the curtilage, the area immediately around your home. Massachusetts says, well, we're not going to count curtilage. So if you have 1 foot outside your front door, we reimpose that legal duty to retreat. You don't have Castle Doctrine privileges anymore. Then Massachusetts will say, well, Castle Doctrine, we say you don't have to retreat in your home, period. But we're going to say that you reacquire that duty to retreat if the person you're fighting with, it's also their castle. So they're a co-dweller. So they're a spouse or they're an apartment mate. If that's who you're defending yourself against, you reacquire the duty to retreat. We don't give you Castle Doctrine privileges. So the general principle still applies. If it's a genuine intruder who broke into your home, you still have Castle Doctrine privileges in Massachusetts, but they constrain it on the margins because they don't like the law. The courts in Massachusetts don't like the legislator passed it over I'll call them the Supreme Court. They use a different term in Massachusetts, but the legislator, the Massachusetts Supreme Court basically said there is no Castle Doctrine. And the legislature, there was a public furor over this. The legislature passed a Castle Doctrine statute, one of the only, maybe the only self-defense statute in Massachusetts. Massachusetts has not codified self-defense. It's all case law. But the legislator passed this over the Supreme Court's objection. And so every opportunity they have, the court has, they constrain castle doctrine in the ways I just described.